turn that sound if it works.
Okay. At first I thought it was a little high because we were getting at first we were getting feedback, but I think it's right now.
Yeah, yeah. Maybe a mistake that over here, but
I doubt it. All right, we're ready when you are, Mr. Swaim.
Good afternoon, Your Honors, and may it please the court. Frederick Swaim on behalf of the appellants, Terral River Service Inc., Navigators Insurance Company. This case is about a 200-foot SCF marine barge, partially sinking in Terral River Service Lake Providence Terminal, where it was delivered for loading. The sinking was undisputedly the result of a 1-foot narrow fracture in the bow rake knuckle on the underside of the barge. The fracture is difficult to see based on the general conditions of the barge, so we've circled the area in question on a photograph on page 38 of our original brief. It looks a bit like a lip bent slightly inward. Upon delivery, the barge, empty, would have sat, the fracture would have sat about 10 feet above the waterline. Once loaded, in connection with industry practice, which is front to back, you don't load on opposite sides because of fracturing of the actual entire barge, and I don't think that's a dispute in this case. Once it was loaded at the front, the barge dipped, and that fracture got to and below the waterline, and ultimately that barge sunk.
how long did the barge sit where it is at its ultimate destination before the rice was loaded? It's 2 days.
The barge, Your Honor, I don't remember the exact amount of time.
It was 2 to 3 days on my count.
I think it was a few days, yes. But again, Your Honor, the entire time, that fracture would have been 10 feet above the waterline.
I understand. I'm just trying to get the time limit.
Yes, Your Honor.
So it's riding high in the water then.
It's right behind the water. And what's really important here, Your Honor, is that this is an inlet
okay, but then
off the Mississippi River going up, so it doesn't get affected by the current. That's why this area is designated as a calm water area.
well, the suggestion is that I guess that when you loaded the rice, it was already there. Once it took the load down, as it intended to do, it came down to, the water level came up to the leak became effective.
That's exactly right, Your Honor. Yeah.
So, if it's sitting still for 2 days there, waiting, being loaded, I know people inspecting the outside, and it's got this large gash I saw a picture of. I'm trying to figure out how this happened.
Well, Your Honor, the only inspection that was done formally was when the vessel was dropped off by the deckhand. And he explained very specifically in a deposition testimony that this former employee, the policies and the procedures were merely to walk the deck and give a visual inspection of it. He's not allowed to go into the holds, the void compartments because of oxygen issues, dangers, U.S. Coast Guard confined spacing restrictions. So he says after this incident occurred, when
it came in unloaded and then was loaded, and when it was loaded within the course of the day, it went down.
Yes, Your Honor.
Okay.
And so I would ask that if you look at that picture, you can see that this is on the rake underneath portion of the barge in the knuckle of it. And you can't even see it with a picture directly looking forward. You can take 10 people and say, what do you see? They wouldn't see it. So we've circled the actual area because it's just a lip in. And the deckhand is adamant that there's no way, he saw this after, and he's testified that there's no way he could have possibly seen this at the time that cursory inspection while they were still in the Mississippi River waiting for the barge to come in. The next point, though, Your Honor, is that all parties agree that the fracture was caused by a green object because it left markings around the fracture in the rake knuckle. And there's a photograph of that at ROA 855. But the evidence establishes that the barge did not come into contact with any such object while at the terminal. In fact, the only greenish object located at the terminal was a barge that was in a fleet at a totally different spot from where the barge was the entirety of the time it was in the terminal, and the records indicate that those objects never could have possibly come in contact with each other. To suggest that they somehow spontaneously met is pure speculation, and that is what the appellees have done.
Well, it's not pure speculation, counsel. I mean, they had this inspection, SCF did, before they turned it over, where the fellow went down into the barge and saw no sunlight, saw a little bit of water, but he said it wasn't enough water for concern. I mean, you get, what is it, 2 inches would have been concern, but a quarter inch not. So you have this inspection that SCF did before they turned the thing over. So that seems to be more than speculation. It was in good shape when they turned it over, right?
Judge Wilson, I respectfully respond to that, in that SCF has admitted that it has no idea what the condition of that barge was when it was delivered. It hadn't seen that barge in forever, and the naked owner, Vessel Holdings, hadn't seen it since delivery. While it was in Terral, 5 days before it was delivered to the Terral facility, it was, there's a cleaning service called C&M in Terral, and they review the barges and walk the deck, and they'll poke their head in the holds, but they don't necessarily go in the holds either.
I thought they did.
No, and they're just there to inspect it for cleaning purposes. But the important point there, Judge Wilson, is that the only evidence that the appellees have offered in this case is from the corporate representative, who just basically said what should or shouldn't happen. He did not train the individual that did it. He never spoke to the individual who did it. He doesn't know what the individual that did it actually did or didn't do. And also to suggest that they had some incentive to find a fracture or damage because then they might get the business. Again, under motion summary judgment standard, that's just pure speculation.
Counsel, help me a little bit about to visualize this. When was the handoff, if you will, I would just, as a landlubber would describe it, of the tug. The client picked it up and at some point and then took it into their harbor. And so how did that happen? Where did it happen?
Yes, Your Honor. Well, it actually starts from where Judge Wilson just left off. It was cleaned down there on May 2nd, and then it took a 300-mile journey up the river with another tow with a bunch of barges in his fleet, possibly green, possibly not, having switched out the entire time. On the 5th day, it was delivered to the facility just outside. And what happens is there's a fleet boat that comes out and meets it in the Mississippi. At this walk-around inspection on the barge happens there, and then the Terral harbor boat brings the barge in. And in this instance, it brought it directly to the loading berth. And at some point, it just pushed a little forward to the next loading berth. Never went in any fleet in the facility. And the green barge that they're saying it came in contact with in the facility never came out of the fleet, which was in a total different area while it was at the facility. And again, I think, Your Honor, it's not genuinely disputed that a green object causes, whether it was a kevil, a barge, or anything else. And we have expert testimony from an engineer, from a metallurgist, from every single witness with direct evidence. Every single witness, deckhands, captains, superintendents, supervisors, anybody with direct evidence will say, have said in this case, and would have said at trial, that there's no way that could have happened that way in our fleet. And that's why, even under bailment theory, Your Honors, we have satisfied the burden. We don't think the appellees can show that they dropped it off in good condition because their corporate representatives have said they have no idea what the condition was at the time. They couldn't specify.
But do they have to show that? I mean, doesn't Terral bear the burden of proof?
So, Judge Wilson, if the appellees can show that they delivered it in good condition and got it back in a poor condition or some damaged condition, then the burden would shift over to the bailee to show, well, I'll be specific. It's Richmond Sand versus Gravel Corp. It's the bailment presumptions. It says specifically, the bailment presumptions do not cast upon the bailee the ultimate burden of proving how the damage occurred. It's a rebuttable presumption, and it shifts to the bailee purely for the purpose of proceeding with the evidence. All they have to do to rebut it is show how the damage occurred and that they weren't negligent. We've done that. We have shown how that occurred. We haven't shown when and where, because it could have been 3 years before.
But that's if they were suing you, right? In terms of the normal flow of things and the burden of proof. I mean, you're suing them, and it seems to me that you would have to show the when and the where. I mean, those are the questions that decide the case, right?
Well, Your Honor, I respectfully suggest that this is still a bailment issue. But even if we had the burden on the preponderance of evidence, we're still proving that there's no way it could have happened in our custody. Think about it this way, Your Honor. If this had happened 3 years before, and this is the first time we've ever seen this barge, how in the world could the bailee be responsible to say exactly when and where it occurred? We didn't have custody of it. We have no idea where it's been. We have no idea who's doing what with it. And for that matter, neither do the appellants. It's all charted to some other people and some other entities.
Where is the evidence that shows that this didn't happen under Terrell's watch?
Well, all of the records that have been produced as far as its time at the facility, all of the deck logs of the fleet boat with the transfers of any barges or anything else, the fleet records of the green barge being the fleet, not coming out, and this barge not leaving the loading areas, the fact that the expert metallurgist and engineer in this case.
Now, wait a minute, the district court excluded the expert.
No, yes, Your Honor. Well, he limited the expert engineer and metallurgist only to the extent that he couldn't repeat a fact that was known in the case, because he said in his report that it was a calm area, which wasn't even disputed. But the district judge says, you can't say that. You're the expert. That can be obtained from other witnesses. He did not exclude the witness from testifying as to the witness markings and the cause of the incident. He was going to testify on that at trial.
Well, so the witness marks and the cause of the incident, again, yeah, something ran into the barge, but the question that Terral bore was where and when. I mean, if the barge was delivered to Terral and it was in good condition, and the damage happened in Terrell's possession, Terrell's claims fail, right?
Well, but I think that we've established that it wasn't delivered in good condition because that could not have happened in our facility. And again, we believe that it's basically, I think that's a Western District of Pennsylvania case that suggests that situation. But the problem in that case was they said,
what you seem to be saying is that we proved the negative. It couldn't have happened with us. Therefore, it must have happened with them. Is that enough?
yes, Your Honor, because it doesn't matter whether it's a maritime negligence claim on a duty risk. It doesn't matter whether it's on a seaworthiness claim or a strict liability theory. It doesn't matter whether it's a bailment issue with a preponderance of evidence issue. In every single respect, we have unrefuted evidence, the only direct evidence in the case, to fully explain that it could not have happened in our facility. And therefore, the burden is on the appellees in that respect. I mean, they have a duty to deliver a seaworthy barge. We don't have a duty to make sure it is seaworthy. We do that cursory inspection as we do with any barge. But we do not look for the things that could make a vessel unseaworthy ultimately if it's a latent defect. In this situation, this is essentially a latent defect. It's something that wouldn't be observable by the average crew member walking the deck of the vessel. And if you look at the picture, I think you'll agree. I mean, you can't even, again, if you took pictures, the panel on the actual, please tell me where the structure is, looking it up close, you might not see it. You wouldn't see it without the circle under it, or you would think it was another area. The barge was not an old barge, it was very beat up. And again, there's just no evidence whatsoever to suggest it happened in our facility. And it gets back to the primary point here that there were so many genuine facts in dispute in this case. I mean, we literally filed a 12-page contested issues of fact in connection with our motion in opposition. The district judge didn't give any weight to that we're aware of, and he certainly didn't give any weight to all of the evidence that said it could not have happened within the facility. And to be clear again, that expert was not excluded from testifying as to that point, and he would have been the only engineer and metallurgist to testify as to that point. But I don't really think it matters because their surveyor doesn't disagree with him. I mean, everybody thinks it was something green that caused it, and it could not have happened within our fleet. And the absence of evidence from the 300-mile journey to our facility, speaks volumes. And the fact again that the CNN report that the district judge referenced in his opinion, no direct evidence of what actually occurred there. I mean, it's pure speculation from a corporate rep who's a business associate of the appellees who said, this is probably how we do it, that's how it should be done. He may have gone in the void, he may not have gone in the void. Also with Mr. Pemberton, we don't dispute or run from the fact that he did fill out a form report after he walked the deck in this case, and he did check every box on there, but he is adamant in his testimony that there's no way he would have seen the fracture. He would have had to go down in the tank, which he could not have done under policies and procedures, and he did witness the fracture after it was raised, and he did testify very specific to that. And the court, this was literally, Your Honors, on I think it was 3 business days before trial, with the motion having been pending for 4 months. We had gone through the pretrial conference, the pretrial logistics conference. We had gone through all the witness preparation.
So what difference does that make? I understood you put that in your brief, but I guess you're just suggesting the district court didn't consider it properly. I'm not sure where that argument takes you.
Not sure what, Your Honor?
The argument you're making, I'm not sure where it takes you. You made it in your brief about the timing of the district court had it, and all of a sudden they ruled against you and so forth.
Your Honor, it just suggested well, in our opinion, it was a complicated issue. In our opinion, it was a summary judgment issue with a lot of different facts. And so we think that just under the straight review of all of the different standard summary judgment cases that we cited, that it's...
Well, okay, I'll take that. But I've not found much out there in terms of presumption of controlling law, but there is an almost identical fact situation in Dunkard, where the court deals with the fact pattern that's right on fours with us, and shifting the burden of proof. And the district court said in the somewhat unusual situation of a barge loader suing the barge owner for the sinking of the owner's barge, it's the plaintiff's barge owner who bears the burden of proving.
Your Honor, I would say that
you just disagree with that.
Not necessarily, Your Honor. It's more typical that it's the bailor suing the bailee for some damaged property while in the bailee's custody and control. That's not always the case. So it still happens the other way around, and the appellees have cited a number of cases where that actually did occur and where these issues were allowed to go forward. And I will also say, though, just to be crystal clear on this point with the motion for summary judgment standard, there's not one case that's been cited here in the briefs for any substantive purpose or benefit that actually was decided on motion for summary judgment. Every one was decided at trial beyond the motion for summary judgment process because of the replete issues of genuine facts and dispute, as you can see here with the different testimony as to when this fracture could or could not have occurred.
All right, Mr. Swaim, you have a red light, but you have been forthright in answering the court's questions. You've reserved your rebuttal time, so why don't we stop there and hear from Mr. Howard, and then you have a right to come back up.
Yes, Your Honor, thank you.
May it please the court. My name is Giles Howard. I represent Defendant Appellee SCF Mrne Inc. and Defendant Appellee Vessel Holdings 7 LLC. I am here to discuss today why the district court's judgment in granting my client's motion for summary judgment on all of plaintiff's claims should be affirmed. This is true for 3 main reasons. First, appellant's allegation that the SCF barge was unfit for its intended use at the time it was delivered to Terral is an essential element of all of plaintiff's causes of action. Second, appellants, as the plaintiffs in this matter, bear the burden of proving that the SCF barge was delivered to Terral in a condition unfit for its intended use. Third, at the close of discovery, appellants have failed to make a showing sufficient to establish this essential element, namely that the SCF barge was delivered to Terral in a condition unfit for its intended use. For these reasons, the appellees ask that this court affirm the judgment of the district court and hold that the plaintiff bears the burden of proof in a civil action. Your Honors asked several questions about the timeline underlying this case. On May 2nd, 2018, C&M Marine, a non-party, not affiliated with my clients, conducted an inspection of this SCF barge. It is the business practice of C&M Marine to have its inspector enter the tanks of the barges that it inspects. C&M is not paid for the barge inspection. It's paid for the barge cleaning, but it is also a barge repair facility. And so Mr. Kevin O'Daniels of C&M testified that C&M does have an incentive to be thorough in its
Let me
inspection.
ask you a question about that inspector. The person that's inspecting that, if he finds a problem, does his company do the repair?
Your Honor, if he finds a problem, he notifies the barge owner and then seeks to do the repair. And because the barge is already at a barge repair facility, it is customary that that facility would do the repair.
I'm just trying to identify his incentive to find problems.
Because it wouldn't make much sense, Your Honor, for SCF to take a barge that's damaged, move it some hundreds of miles on the river to a different facility. So that's the incentive that C&M Marine, a non-party, unaffiliated with my clients, has to do a thorough inspection. That barge was then inspected 5 days later on May 7, 2018, by Terral's deckhand, Mr. Corey Pemberton, at the time that Terral took custody and control of that barge. Now,
The inspection wasn't as detailed, I guess, as far as what Terral did, right? In other words, the deckhand says there's no way I would have seen this damage.
the inspection, Your Honor, is not as detailed as what C&M Marine did, because the practice and procedure of C&M Marine is that the inspector fully enters the void tank of a raked barge. And of course, this fracture was in the port bow raked knuckle of this raked SCF barge. But importantly, the Terral deckhand, though, he doesn't just walk about the deck of the barge. He testified that he opened a hatch cover in the bow void tank and looked inside. And he didn't see any light, and he didn't see any water.
Didn't he also say he wouldn't have seen this?
Well, Your Honor, he said that after litigation had commenced.
No, but he testified to it, right?
He did, Your Honor, but importantly, he also testified that he did not see any water in that void tank, and that he did not see any light in that void tank, and that if he had seen light or water, those would be indicative of a fracture. And in that event, he would then seek the appropriate safety tools to fully enter that bow void tank. Because as C&M has an incentive to find flaws in barges, Terral also has an incentive to be thorough in these inspections because it doesn't want to get blamed.
Well, we wouldn't be here. I mean, they have an incentive probably not to be here today, right?
Yeah.
But he said he wouldn't have seen the fracture, and so is that enough to create a material issue of fact?
No, Your Honor. I think what's important about Mr. Pemberton's testimony is that he testified that he did not see light when he looked in the bow void tank on May 7 when he conducted the documented inspection. And then he testified that after the barge was salvaged, after it had sunk and been raised, that he looked inside the void tank and he saw light. Because if there's a fracture in the hull of a barge surrounding that void tank, that fracture, if you look inside the void tank in daylight, that fracture would let daylight in. And so Mr. Pemberton did not see daylight in that void tank on May 7, and he inspected it during the day. He inspected it during the day. He did not see light in that void tank on May 7, but he did see light in that void tank after the barge was raised.
But what about counsel opposite's argument, if I can summarize it fairly, if not, he'll correct on rebuttal, that, well, they proved that it didn't happen when it was in their custody and care. There's no way it could have happened. I mean, is that enough to sustain their burden?
No, Your Honor. An essential element of the plaintiff's causes of action in this case is that the barge was delivered to them unfit for its intended use, i.e. with this fracture in it. They have to prove.
But their argument is it was latent.
Respectfully, Your Honor, they lean on the photo that they include in their brief, Your Honors, to suggest how hard it would be to see that fracture. But that photo was taken after the barge was raised. So that photo is not necessarily an accurate depiction of how it looked before it had sunk and been on the bottom of the river for several days. But I would respectfully suggest, Your Honors, that Terral provides us the best proof that that fracture did not exist on May 7, because that inspection report that Mr. Pemberton created that appears on Record of Appeal, page 554, that report has a number of specific areas of a barge that the inspector is supposed to check for damage. And Terrall's 30-6 designees testified that the purpose of this inspection is in part to check for pre-existing damage. So there are some specific parts that the deckhand is supposed to look at, and that includes the wing tanks, the timber heads, the kevels, and it also includes the knuckles. And there's a spot next to each of those specific items where the deckhand can check if you looked at them. And if you look at Record page 554, Mr. Pemberton, when he completed this report, he checked next to Knuckles. And there's a spot next to that check mark called Remarks, where if a problem is noted with any of those specific parts of the barge, that the deckhand can then note the problem. And Terral, through its 36 designees, specifically testified that that is the purpose of the Remarks section, that if you see a problem with the barge, the deckhand is supposed to write down the problem under Remarks. And so not only is the space next to Knuckles on this barge inspection report checked, there is also nothing under the Remarks section.
All right, so he missed it. He missed it. But if it didn't happen under Terrell's watch, is that enough to defeat their claim?
No, Your Honor, because that's not what they need to prove. But respectfully, I'd suggest that if someone right now, if the shoe were on the other foot, someone was blaming Terral and saying that the fracture existed at the time of delivery, they'd be leaning on this report to show that no, they took in a barge in good condition. That's why bailees create these inspection reports. So there's no doubt about the condition of a barge at the time that the bailee takes custody and control of it. And I would suggest, Your Honors, that this barge inspection report is the only contemporaneous evidence of the condition of the barge on May 7 of 2018. And it was created by Terral. It is the best evidence of that barge's condition, and it specifically requires the barge inspector to look at the knuckles. It indicates that the knuckles were checked. And that is the best evidence of this barge's condition on May 7 when Terral took custody and control of it. And the essential element of their claims, all of them, the essential element is that the barge arrived and was provided to them in a damaged condition. That's what they need to prove, Your Honor, not to raise some sort of speculative doubt about whether it possibly could have occurred at their facility. Now, there are those green witness marks on that fracture, which respectfully we suggest makes it more open and obvious, the green paint marks along that fracture. And it is true that the testimony in this case is that it could have been caused by a green object. SCF's expert surveyor has also argued that it could have been caused by an object where the paint had transferred to a non-green object, because on the river these barges touch things, okay, and it is conceivable on the river that green paint would have rubbed off onto a deck fitting of a non-green barge. So the agreement's not exactly as cut and dry on that point, but I don't think we need to get to it, because what's important is that we have this inspection report from May 7. There's no photographs from May 7 or before. There's no videos from May 7 or before that show a fracture. There's no witness testimony from someone saying that they saw a fracture in that barge on or before May 7. Instead, we have this barge inspection report that is clear as can be that the knuckles were checked, and there is no notation of damage to those knuckles, and it was created by Terral. And Terral has done everything it can throughout this case to distance itself from its own business record. But the business record exists, and it's our only piece of contemporaneous evidence. And I would respectfully suggest that Mr. Pemberton's own testimony about not seeing light when he looked into that void tank on May 7 during the day, and then seeing light after the barge was raised, I would suggest that further bolsters the accuracy of the inspection report that he did on May 7, because if that fracture had existed on May 7, you'd expect him to see light shine through it when he looked in those void tanks, the same as when he looked in those void tanks after the barge had been raised. I want to talk briefly, Your Honors, some questions were also raised about the burden of proof in this case. Mr. Swaim has addressed the question in terms of bailment law, but the opposing parties did not make a claim under bailment. Okay, they made a claim for general maritime negligence, for unseaworthiness, for salvage, for breach of warranty, indemnity and contribution. They did not make a claim under bailment. And as one of Your Honors pointed out, it is somewhat unusual, this situation we find ourselves in where the bailee is suing the bailor. We've only found 2 cases where a court has addressed that situation, but both those cases out of the Western District of Pennsylvania, Consolidation Coal Company versus U.S. Steel and Dunkard Mining Company versus Mon River Towing, both of those cases agree that in this somewhat unusual circumstances, it is the plaintiff bailee who bears the burden of proof on the allegations of unseaworthiness. the plaintiff bailee. That's what's important, is the bailee's identification in those cases as the plaintiff. And opposing counsel also raised the case of Richmond Sand and Gravel. And we actually quoted that case. In our brief, Your Honor, we directed the court's attention to that decision in which they said, quote, "It is thus solely a procedural device and does not in any way affect the ultimate burden of proving the bailee's negligence, which burden remains throughout with the plaintiff bailor." Just to highlight that in that case, it was the usual case where the bailor was the plaintiff. That's why the burdens rested the way they did on the bailor in that case. But in this more unusual case, where the plaintiff is a bailee, the burden rests with the plaintiff to prove a vessel's unseaworthiness.
Do you agree with counsel opposite's qualification about the exclusion of the expert testimony?
No, respectfully, Judge, I differ with opposing counsel on that. Mr. Bartlett, the metallurgist, opposing counsel leaned heavily on Mr. Bartlett in trying to suggest that Terral can prove that the damage didn't occur at its facility. And the district court's decision on Bartlett is important. The district court identified 3 areas of opinion that Mr. Bartlett was offering. And they're important enough, I think, to read them here. One was that the Terral loading facility is located in a finger of water connected to the Mississippi River, which was protected from the current. And as a result, it is inherently less hazardous and therefore less likely for an elision or collision to occur than a berth exposed to the Mississippi River. Now, the district court struck that opinion because Mr. Bartlett agreed that he did not measure the current, and he would have needed to do that for that opinion to be reliable. So the district court struck that one. Now, Mr. Bartlett also testified that the hull fracture more likely than not occurred at a pre-existing time before the barge arrived to the Lake Providence area on May 7, 2018. And what we argued below was that that was just a gratuitous interpretation of the facts by the expert witness, and that it is not the role of an expert witness to serve as a fact finder. That doesn't add value, and we sought to exclude it on that basis. And the court agreed with us on that interpretation. And then Mr. Bartlett's third opinion from his report was that considering the slack water in the lake at the Terral facility and the lack of maneuvering required of the barge in order to bring it in and ultimately bring it to the port dock, the puncture and fracture would not be expected to have occurred while the barge was at the Terral Lake Providence facility. And Mr. Bartlett had also testified to his lack of navigational experience and expertise. He's not a towboat pilot. He's not a towboat captain. And so the court agreed with us that he couldn't testify to navigational subjects because he lacked that area of expertise as well. So the only thing that the court allowed Mr. Bartlett to testify to, the only way in which our motion was denied, was that to the extent defendants object to the portions of Bartlett's report and testimony which rely on the witness marks on the basis that he did not use reliable principles or methods, the motion is denied. I'd respectfully suggest that we struck more of Mr. Bartlett's opinions than opposing counsel has admitted to, and they have focused on this line from one of his depositions about how he doesn't see a mechanism by which the damage could have occurred at Terrall's facility. But it's unclear what the basis is for that opinion, and to me it seems like it falls more within the report opinions that the court excluded in granting partially our Daubert motion as a gratuitous inference about the facts and something that Mr. Bartlett didn't have the requisite expertise to testify to and didn't have.
Counsel, let me shift gears slightly with you, please, sir. You filed a counterclaim, which I take it was sort of implicit in this implicitly resolved by the court's order, but I'm not sure what the status of this is.
The counterclaim, Your Honor, remains pending. My clients moved for summary judgment solely on plaintiff's claims against them on the basis that plaintiff had not, at the time of close of discovery, introduced sufficient evidence on an essential element of their claim, i.e. that the barge was delivered in an unfit condition. SCF did not move on its counterclaim, so that remains pending, Your Honor.
Okay, so what's the status of it? It's just there?
Well, after the court ruled on the summary judgment motion.
There was a salvage claim out there go ahead, I'm sorry.
Well, Your Honor, after the court ruled on the summary judgment motion, opposing counsel indicated their intention to seek an interlocutory appeal,
Right.
and the court therefore stayed the trial. So,
Yeah.
following the resolution of this
Yeah.
appeal, the counterclaim remains to be resolved with the district court.
Well, I've always found the A3 provisions of 28 U.S.C. 1292 to be a little, it's at the margins, a little elusive sometimes about interlocutory character, exception for admiralty, and the way it's phrasing. I just want to be quite clear that we have no problems there. I didn't want that to come sneaking in at the last. Jurisdiction has a way of doing that sometimes.
Your Honor, we did not attack jurisdiction in this matter. Of course, the court.
Well, I know
has
you
to
wouldn't. I
decide.
know you know what you certainly wouldn't. But the problem is that we have to assure that we do have it. And the statute is unique to admiralty, and that's intended to be to tolerate the appeals. But the language of the rule itself is that it speaks in terms of resolution of claims. But I just want to give you a heads up on that, we're quite clear that we do come well within the compass of the statute. It appears to be that we do, but I just want to be quite clear about that.
Yes, Your Honor.
Yeah.
We're familiar with that the contours of 1292A3 can be vague, and we understand that Your Honors must also be satisfied with your jurisdiction regardless of what the parties say. And of course, if Your Honors are not satisfied with your jurisdiction, I'm certainly not going to fight you on that.
Well, it's quite clear if you grant a summary judgment, for example, you obtain a summary judgment, or you obtain a ruling of liability, for example, you can bring that up, sort of an implicit bifurcation. Admiralty enjoys that wide door to the appellate court. But then we had a couple of other claims that were back and forth. I thought your counterclaim was in essence implicit. It's sort of the response back the other direction, but be implicitly determined by the ruling the district court made.
I like my chances, Your Honor, but it does remain pending below. I see that my time is about expired. We ask that Your Honors affirm, and if you have no further questions, I'll rest.
All right. Thank you for your argument, and we'll now hear Mr. Swaim on rebuttal.
Thank you, Your Honors.
May it please the court, Your Honors, we're only talking about the summary judgment standard here. And all of the direct evidence that's been offered and was going to be offered at trial by witnesses was purely on behalf of the appellants. The appellee had a surveyor that was never present for anything, even in connection with his surveyor who was going to testify. They have corporate reps who admitted in their depositions they had no clue what the condition of the barge was at the time. And yet the appellants had all of the captains, the deckhands, corporate representatives. They had their own surveyors who were there. They had their engineer who reviewed this and is the only engineer in the case. And so, I would pose that the testimony of Corey Pemberton, if they're going to squarely rely on his report, is good enough to defeat summary judgment. As far as the CNN report, that was 5 days before, 300 miles away, and we don't even know what that individual did. That's absolutely speculation as far as that report. Mrs. Howard is a talented lawyer and represents his clients well, but the appellee's arguments are flawed in that, again, they have no direct evidence regarding the cleaning report, and the report, in fact, does note water, which should create an issue in and of itself. They provided no evidence regarding the barge's journey to the delivery point, despite that being their contracting party. They can't meet the burden as to Mr. Pemberton because his testimony speaks volumes. He's adamant. He clearly says, I would not have seen that, and that's at least good enough to go to a trial, in our opinion.
Counsel Option says they excluded more than you owned up to in terms of the residue of his report. He says that in and of itself kind of knocks you out the box.
The basis that counsel explained as far as Bob Bartlett not having enough navigation experience to comment as an expert on navigation is accurate, but it doesn't change what I said before. He was limited on that issue of the calm water and how you wouldn't have that flow of the current and vessels affecting things from a navigation standpoint. But the bottom line, Your Honor, is it's not disputed. None of it's disputed. The appellees actually cite in their motion, I think we put this in our brief, in another motion that the water was calm. They used it to their advantage. It's an inlet that just doesn't have the current of the river. So as to Mr. Bartlett, which is why we didn't challenge that opinion, is because it was insignificant. There was factual, the court basically said, there's facts that can testify to that. Fact witnesses, you can, as an expert, say that, something that's potentially navigation. But they absolutely were going to allow them to testify to the witness marks, the green marks. But you know what, Your Honor? That's not disputed either. Their surveyor said that it was the green marks and it must have been a barge. In deposition, he tried to say, well, maybe it was a kevel, maybe it was something else. It was some green object. But we can establish through all the direct testimony of witnesses that actually know the facility and were there, couldn't have happened in our facility. There's no way. And as far as any issue, just to quickly address this, Your Honors, as far as the briefing about potential waiver, a breach of warranty, contract, or salvage claims, there was absolutely no waiver in any respect. And we covered everything in our 12-page statement of contested facts in the motion practice process. And
Let me ask you this.
Yes, Your Honor.
In a 1, 2, 3 bullet point way, tell us what the summary judgment record consists of. Just 1, 2, 3, 4, 5, 6, 7, 8. Just look at the record through. Just boom, 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 boom.
You mean the record as we presented to this court?
Yeah, it's up here on summary judgment. You're saying you should have got a trial. The other side says nope. You had plenty of chance to satisfy your burden. You didn't. So summary judgment, they're entitled to as a matter of law. So I'm just rat-a-tat-tat. We know about the expert report. We know about what else? What else does the summary judgment record consist of?
Your Honor, the summary judgment ruling focuses solely on the issue, and I can quote it, specifically the court stated, to find a genuine issue of material fact.
That wasn't my question. I said, tell me 1, 2, 3, 4, 5. What does the summary judgment record consist of?
It consists of from the appellee's perspective, the C&M report, testimony from the C&M representative, the inspection report from Mr. Pemberton for Terral. It is Mr. Pemberton's declaration and Mr. Pemberton's testimony. It is all of the captains that would have taken this barge in and out or would have moved anything else around within the facility. It is, or at least one captain, another was going to testify to that point that wasn't there at the time this was being loaded. I believe maybe another deckhand. It's the corporate reps and supervisors and superintendents for Terral. It is the SCF representatives testifying that they didn't know what the condition of the barge was. It's all of the documents from the facility that show where the vessel was, where it went, what happened and what didn't happen, the load times, the load reports, the weighing of the rice. It includes expert opinions in it from surveyors and from, I believe, the metallurgists, testimony from those individuals. It includes the relevant information in the case, which we would represent is 100% as far as the direct evidence in support of the appellant's claim, and only as far as individuals that don't have direct knowledge as to the appellee's claim.
Right, so it sounds like the summary judgment record is pretty packed in terms of, what's there. More so than a lot of summary judgment, we don't have an issue about the exclusion of evidence other than the report, but it sounds like the summary judgment record is pretty full. So the question is, from your standpoint, you say that should have left fact issues that got you to trial. The other side says everything that could have been there is there, and the judge decided that even taking the evidence in the light most favorable, you didn't meet your burden, you lose summary judgment. That seems like what it kind of boils down to, right?
Correct, other than the fact that the opinion is limited to only a very small portion, in our opinion, of what we just talked about.
Okay.
And also there were, I believe, 11 witnesses that would have testified on behalf of the appellants, all with direct knowledge, or 9 with direct knowledge that the court never got a chance to hear from. Okay. Particularly, again, the credibility issues from a motion for summary judgment standpoint, from Mr. Pemberton, who specifically addresses the issues that they're relying on. And when they say, when the appellees say, well, the C&M, at C&M they do this and that would have done that, again, Your Honor, that's pure speculation. There's no evidence of it that was in the record. The one thing that's missing, Your Honor, from the record, subject to the question, is that whoever performed the inspection at C&M never testified. No evidence offered from him. It was Mr. Pemberton. And then everything after Mr. Pemberton was, this could not have happened at the facility.
All right. Okay, well, that's helpful.
I wanted to ask real quick, I know you're out of time, but if you could comment on Judge Higginbotham's question about jurisdiction. Do we have it?
Yes, Your Honor. I know that we, I guess we can take a separate section of brief and report beyond just the jurisdictional statement, but my understanding is that we absolutely have jurisdiction, that the court absolutely has jurisdiction in this scenario.
I appreciate that. That's my supposition too, but I wanted to apply it to this record because you had some loose ends of, you had things that weren't resolved, et cetera. It's a pretty wide sweeping doctrine. I would say from my own standpoint, I appreciate the maritime lawyers that come over here because they probably because your frequent flyers and statutes like that open the door so wide, we hear from you a lot, but you always do a good job. And from guys that live out in the Grant Hill country of Texas, I need all the education you can give me. So.
Thank you, Judge. Thank you very much.
All right. I take it, Mr. Swaim, you're in the ancestral chain of one Frederick Swaim who used to teach at Loyola?
Yes, Judge Stewart, I am. That was my father.
Well, I remember that case.
Well, I had him grab me, and I won't tell you what kind of grade I got. So,
Well, Judge.
in any event, I have a feeling that it doesn't endure for or against it. It was a curiosity question. I just had to ask. I started having flashbacks when I was sitting up here. And I
Well,
won't tell
Judge
you whether
Stewart, so do I, because I had him for a teacher in the summer, and he was pretty rough.
I won't tell you whether they were good or bad. But anyway, we appreciate the arguments. It's an interesting case. We don't get a lot of these, so it's always interesting to get us into some aspects of the law. I live in North Louisiana, to be honest with you. I wasn't necessarily big in Lake Providence as being kind of the upper regions of navigability and water and all that sort of stuff. So I had to pull out kind of, it has nothing to do with marriage. It's just I lived in North Louisiana, and so when I'm looking at the map and the piece and the finger going that far up, and I'm like, well, okay. So anyway, that's just to applaud you lawyers. We do appreciate those of you who do this, so it helps educate us because we don't get a lot of them. And so we'll square it up. We appreciate your briefing, your oral argument in the case. It'll be submitted and we'll get it decided. That completes the orally argued cases. We had one other one, but regrettably it had to be converted. So along with the NOA cases, they'll be submitted. Otherwise, the panel will be in recess until 1 p.m.